Greetings, my fellow freedom-loving sovereign thinkers. Thank you for tuning in to LL3 Podcast. My name is Craig, transmitting from the wild, wonderful mountain states. And today's date is Sunday, August 29th, 2021. Yep, hopefully everyone out in the Louisiana area, hunker down, be ready. Don't roam around. I was watching some of the cameras, hurricanes coming, and I see one guy roaming around on Bourbon Street. It's totally ludicrous, but but you got folks always gonna have that mindset. So everyone out there, please be safe, because we are concerned as well. And of course, I was watching a report in South Africa. The South African Communist Party supports universal basic income. So they want slavery 101. Instead of people in South Africa become natural born human beings, they want you to be a number, slavery, peasants, take everything from you so they consolidate all the wealth themselves. That's the Communist Party for you. Another form of tyranny. And everyone out there has to realize, if you trust the government, then you failed history. Plain and simple. And, this is just one of those things. It's raining on and off over here in West Virginia. Just kicking back. And I just, this thing just passed me about a report here passed me. It came out actually August 23rd. It's from the National Rifle Association for Legislative Action. So, and actually, I know it's from the JPFO. So I was out to check this out. It says here, red flag case, Florida man's rights virtually disappear. And I don't know who wrote this. I'll see here. No, there's no author, but we'll carry on. President Biden and his Attorney General, Merrick Garland, have championed red flag laws that authorize courts to temporarily prohibit individuals from possessing or accessing guns based on unapproved and uncorroborated allegations by family members, co-workers, law enforcement officers, or others. A key feature of these laws is an initial order that is imposed ex parte without notice to the affected person, where he or she has no opportunity to attend to contest the allegations. The model legislation prepared by the Biden administration authorizes such an initial order together with a concurrently issued warrant authorizing a new law enforcement agency to search the person of the respondent and any such place for firearms and to seize any firearm. The gun ban and confiscation remain in place until a second court hearing for a final order occurs, which may be weeks later. Only with respect to this hearing does the person have the right to due process, to advance notice of the hearing and to appear, challenge the basis for the order, and present their own evidence. The NRA, as have other critics, has voiced concerns over the lack of due process, impact on civil liberties, the flimsy standards, and a process that is slanted towards the issuance of an order. Supporters dismiss these concerns. After all, the ex parte order and concomitant loss of gun rights and personal property is technically temporary, and the lack of notice and an opportunity to appear are rectified during a later hearing on notice. A recent case in Florida illustrates one of the many issues with these orders. On May 31st, 2020, officers of Lakeland, Florida Police Department petitioned for a risk protection order under the state's red flag law against EP. Officers took EP into custody and seized his firearms and ammunition. The ex parte order served on EP instructed him that the hearing on the final risk protection order was scheduled for January 12th, 2020 at 2 p.m. in the court facility located at 255 North Broadway, Bartow, Florida. This date, time, and place were confirmed on June 3rd by the police department's attorney and again in the court notice issued prior to June 12th. EP presented himself at the appointment date and place at 1:30 p.m. and waited until 3 o'clock. He testified that he was not let into the courtroom, nor was he aware that the hearing would take place virtually or how to attend. In fact, the hearing was held as a remote video conferencing event without notice of this change to EP. At that hearing, the court determined incorrectly that EP had elected not to attend and entered a RPO against him. EP was prohibited from having custody or control of purchasing, possessing, receiving, or attempting to purchase or receive a firearm or ammunition for up to a year, and was required to surrender any guns or ammunition not already in the custody of the police to law enforcement. This isn't too surprising. Florida news sources analyzing RPO cases in the two Florida counties found that such petitions were overwhelmingly likely to result in order against the defendant, with judges granting orders in 90% of all cases. Fewer than 2 in 10 respondents have been represented by counsel. These proceedings are civil in nature, so respondents aren't eligible for assistance from public defense lawyers. EP appealed the order against him on the basis that it was made without giving him an opportunity to appear or notice that the proceedings would take place by means other than those designated in the court's official documents. The state law, Florida Statute 790.401, subsections 3A and B, mandates that a court must issue a notice of hearing to the affected person and may issue a final order upon a notice and a hearing on the matter. It was not until August 13, 2021, that the court's order was invalidated. A unanimous panel of the appellate court ruled that EP's due process rights were violated by the failure to notify him that the final hearing would take place virtually instead of in the court facility listed in the ex parte order. Citing Florida case law, the court observed that the procedural due process requires both fair notice and a real opportunity to be heard at a meaningful time and in a meaningful manner. The lack of proper notice deprived EP of his right to be heard, and accordingly, the order must be reserved. The case highlights of the weakness of a model predicated on the presumption that persons named in the petition are dangerous, and that it is therefore appropriate to strip them of their rights and property without notice or a meaningful opportunity to respond until after the fact. EP was obligated to spend time and money to undo the trial's court's blunder. And even so, there is no indication in the case report that he had his property or his gun rights restored prior to the appellate court ruling. There's the case on here, EP versus Lakeland Police Department, and you can look that up yourself. And I'll be very frank, my friends, this whole red flag laws, extreme risk protection orders are illegal, period, under the Florida Constitution, Article 1, called Declaration of Rights. And I'll give you a few right here under the Florida Constitution. So, one moment here. Ooh, looks like I goofed up. No problem. But actually, when you look at these things, it would violate Article 1, Sections 9, 10, and 22, at the least. 3 laws under the Florida Constitution. And it's blatantly unacceptable. And I spoke my mind on this, and it really dawns on me when you got these imbeciles think they're smarter than the supreme law. And this is why, even with the language, when the red flag law was in the Stoneman-Douglas Protection Act, that is called Stoneman-Douglas Protection Act. To have armed guards or armed people that are armed, including teachers, if they gotta go through the whole proceedings. But when you look at all this, they violated his His rights. And of course, I could hit Article Section 2, Basic Rights. All natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and defend life and liberty and pursue happiness, to be rewarded for industry, and to acquire, possess, and protect property. And we'll leave it at that. And if you hit Section 9, due process, no person shall be deprived of life, liberty, or property without due process of law, or be twice put in jeopardy for the same offense, or be compelled in any criminal matter to be a witness against oneself. So they never gave them a due process, and they clarified in that one statute that I addressed the aforementioned. And here's another one too: prohibited laws. No bill of attainder, ex post facto law, or law impairing obligation of contract shall be passed. That language in that Stoneman Douglas law on risk protection orders is invalid, is impairing. So it's null and void. That's Section 10. And of course, he got search and seizure, Section 12, which is equivalent to the Fourth Amendment U.S. Constitution. And we can go all the way down here. And what's funny, because they claim this to be a civil trial, okay? A civil case. I'm doing my home research on their risk protection order hearings. And 22 says here, access to court. The court shall be open to every person for redress and injury. Yes, Section 21, by the way. And justice shall be administered without sale, denial, or delay. Here's 22. The right of a trial by jury shall be secured to all and remain inviolated. The qualifications and the number of jurors, not fewer than 6, shall be fixed by law. Well, here's the thing. See, it doesn't matter if it's criminal, civil, etc. The respondent or defendant has a right to have a jury of his peers. And that, the risk protection order, does not allow that. So the truth of the matter is, the red flag law in Florida is void and with no force. Without force, excuse me. And anyone trying to refute that, prove me wrong if you dare. And that will be it. I want to thank everyone for listening. Plus, feel free to download and share this throughout your social media networks. If you have any questions, comments, or sense interesting, check out whatever you do, please send your correspondence to Quorum. For the moral, leave the footnote of this article and the article in the Florida Constitution on my Spreaker page. If you want to contact me, you can go to LookYourLuck number 03 at protonmail.com. You don't do a donation. You can go to paypal.me or cash.app/LookYourLuck number 3. If you want to support the NRA, ILA, that'll be fine. I have my differences with them too. There's some areas I'm not too fond with. However, it looks like the membership too are learning or bettering themselves, and they're letting them know, their board. This has to be done. So that's good. I'm glad they put this out, and everyone has the right to know. So that will be it. Once again, thank you for your time. Plus, always remember that the demoniac resistance is healthy for the soul and can liberate humanity. Until next time, take care of yourselves. Keep on spreading love. And may your guardian spirits be with you.